Hello everyone and welcome to today's Mondac webinar in association with Macarim and Tyra S, who will be exploring the practice of employment transfer under Indonesian manpower law. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Leah Alizia is a partner at the firm and has for 2 decades been a trusted advisor and litigator for multinational corporations and global brands. Adept at handling major cases, her expertise spans employment, restructuring, anti-competition, intellectual property, and dispute resolution. She excels in corporate governance and estate issues, maintaining the highest ethical standards in representing clients before Indonesian courts and arbitration panels. Leah regularly advises on employment, anti-bribery, anti-corruption, and IP enforcement. Next, we have Made Susanti. Susan joined M&T in 2017 and since then she's been contributing to the firm's litigation, manpower and corporate and commercial teams. She has assisted and represented prominent clients in several dispute resolution cases, including civil disputes, employment disputes and arbitration cases. She has also assisted and advised foreign and domestic clients on various corporate matters. Susan has been involved in representing and advising clients with dispute resolution and litigation matters. Now, before I hand over to our panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session at the end of today's presentation. It's now my pleasure to hand you over to Leah and Susan to begin. Thank you.
Thank you, Dan, for the introduction. So today we would like to explain about the employment transfer under Indonesian Manpower law. So there will be 4 major points that we need to discuss in our presentation. First, what is transfer of employment? Second, procedure for transfer of employment. Third, important points and frequency asked questions on transfer of employment. And lastly, about alternative method to transfer an employee. Next slide, please. What is a transfer of employment? Next slide. So basically, this issue is not regulated in our manpower law. So this happens in practice, and usually the transfer of employment occurs due to the restructuring or there is a business transfer or asset transfer. Next. The key point of the transfer of employment is that there is a change of employer. So it means that because of the change of employer, all the employment relationship, the matters related to employment relationship, transfer from the old employer or the current employer to the new employer. Next slide. This the transfer of employment happens is because, for example, the need of the employee to work in the new organization. For example, in the business transfer or the asset transfer. So if there is a transaction here and the new employer needs a certain skill, for example, for doing the business after the business transfers completed, then there will be a need for the transfer of employees from the current employer to the new employer. So it means that it might happen that it's only certain employee that will be transferred, but the rest employee could be terminated. So in this case, when we said transfer, it means that all the benefits of the employee will be also carried forward to the new employer. So this includes the salary, benefits, length of service, untaken leave, and so on. So before we continue with the explanation, with the further explanation, so I would like to explain about the definition of employment relationship here. So employment relationship means that the relationship between the employer and employee based on employment agreement containing the elements of work, wage, and order. It means that if there is a transfer employee, so all these elements will be transferred to the new employer. Next slide.
For now, we'll discuss a little bit more about procedure for transfer of employment. As Ibu Lia explained earlier, the transfer of employment itself is not expressly governed under Indonesian manpower regulation. So there is no procedure or mechanism to ensure that this transfer of employment is actually valid under Indonesian manpower law. So how do we determine what is the proper procedure to do it if there is no regulation about it? As you can see in the screen here, this is actually a recommended procedure that was developed during practice and also in our experience in handling transfer of employment matters. We believe that this is the most straightforward method while still trying to protect the interest of the parties, including the employers and the employees. First of all, for the transfer of employment, there are three parties involved: the old or current employer, the new employer, and the employee. Now, before we start this procedure, usually the old or the current employer and the new employer have already discussed and agreed on what are the terms of the transfer itself. So once those terms are agreed, the first step is to first propose and explain the transfer of employment to the employee. I say propose here because one of the key points of transfer of employment is actually consent from the employee. Transfer of employment can be done through mutual agreement. It has to be agreed by all parties. So the current employer would meet and discuss and propose the terms of the transfer to the employee first. There's no standard format on how we do this. Usually it's a face-to-face meeting or maybe like a Zoom call or something like that where the employer can explain the terms more comprehensively. If there's multiple or maybe like 10 or 15 employees that are being transferred, you can do a town hall meeting first and then a one-on-one meeting when necessary. So first, after we propose the terms of the transfer to the employee, there are two possibilities. First, the employee would agree with the transfer, or the employee would reject the transfer. For now, let's focus on what would happen next if the employee agrees with the transfer. There is no complicated procedure to do it. You just need to execute some of the necessary documents. Now, as I said, there's no statutory procedure, so there's also no list of required documents under the manpower law. But in general, in common, usually there are three required documents in order to affect a transfer of employment. Next slide, please. Okay, the first one is the employment transfer agreement. Now, this is a tripartite agreement, meaning that it is signed by three parties: the current employer, the new employer, and the employee. It must be made in Indonesian language as governed in the Indonesian language law, or at least in dual language containing Indonesian, so in English and Indonesian, for example. There's no standard format on how the employment transfer agreement must look like, or any mandatory contents or clauses under the law, so it can easily be adjusted to accommodate the agreements or the agreed terms of the parties on a case-by-case basis. So the content itself fully depends on the agreement of the parties involved. Next slide, please. The employment transfer agreement would set out or contain all of the terms of the employment transfer as agreed by all relevant parties. As there is no mandatory clauses to be included, we have pinpointed some important clauses which encapsulate the transfer of employee itself. The first is what is the reason for the transfer of employment? This is highly recommended to be included for the sake of clarity of all the parties involved. So there's no misunderstanding on why the employee is being transferred to another company. The second is the effective date of transfer. This is important to pinpoint when would the employment be assigned or transferred from the current employer to the new employer. This is important for all the parties involved, especially to the employee, to know and make certain of, because it would affect a lot of employment-related matters such as payroll. Once the effective date of transfer hits, then payroll obligation removed from the current employer to the new employer, or which internal policy or internal regulation which will apply to the employee. After the effective date of transfer, then the internal policies or internal regulations of the new employer will become applicable to the employee. Next point is to emphasize that once the transfer is effective, the employee is no longer employed by the current employer. This is highly recommended or highly advisable to include this emphasis. This is to avoid any claims of double employment. Especially in this issue, since there are two employers that are involved, it is crucial to determine that and confirm that the employee agrees that it would always be only one employer. There would not be any time where he or she is employed by two entities at the same time. And then the fourth point is the acknowledgement of years of service at the current employer. As Ibu stated, that in a transfer of employment, the employment itself exists. It continues just with another or a new employer. So this new employer must acknowledge and carry forward the years of services of the employee with the previous employer. Point number 5, carry forward of ongoing benefits and entitlement. The examples are, annual leave, the remaining annual leave from the current employer would still be acknowledged at the new employer, or bonus calculations for certain types of positions, such as maybe like sales or marketing. Usually they have a separate bonus calculation or incentive calculation. Now that would still be honored and recognized in the new employer. And the last is the waiver of termination-related payments. This is a very important point because sometimes people misunderstand transfer of employment as a termination, and some will ask for their severance pay. It's important to note that to the employee that this is not a termination. The employment relationship still continues to exist, just with a new employer. So there's no termination-related payments like a severance package or a separation pay, any kind of financial obligation from the current employer to the employee. Next slide, please. So that's for the first required document. The second is the new employment agreement. Of course, that once the effective date of transfer, then the employee would be employed by the new employer. But it's always beneficial for all parties involved, and for the sake of clarity and certainty, to have a new employment agreement between the new employer and the employee. Again, this must be made in Indonesian language, or at least in dual language, English and Indonesian, for example. And because it is an employment agreement, then the contents must satisfy the statutory requirement of an employment agreement under the manpower regulations. This would, set out the terms of employment with the new employer. Usually, it is not much different than the existing employment agreement with the current employer, because I stated that the remuneration benefits, it follows the employee, so it would not be that much of a change. But it's always beneficial to reconfirm and reiterate these points, especially when involving a new employer. Next slide. Okay, for the new employment agreement, in addition to the general terms of employment, like salary, work hours, rest day, work days, rights and obligation of the employer and the employee, because this occurs after a transfer of employment, there are some recommended additional clauses that are important to be included. Number one is the commencement date of the employment with the new employer. Usually this would be the same date as the effective date of transfer, but it is advisable to, emphasize or reiterate the commencement date. The second is the acknowledgement of years of service at the previous employer. This would be similar or even the same with the terms in the employment transfer agreement. So whereby the new employer would acknowledge and carry forward the years of service of the employee at the current employer. But if you read together with point 1, then the article usually stated something like, so the commencement date with the new employee, the new employer is, for example, X date, but for the purpose of, the acknowledging the transfer of employment, then the previous years of service is still going to be acknowledged by the new employer. The third point is to carry forward of ongoing benefits and entitlements. As mentioned earlier, annual leave would still be recognized and carried forward to the new employer. Bonus calculation, similar as well. Usually this specific point would be a crucial point for the employee because they want to make sure that what they got at the current employer or the previous one will still be recognized in the new employer. So it's very important to include that in the new employment agreement. As a general note, it is always it's a key point in the transfer of employment that remuneration and mandatory benefits in the employment agreement must be equal or more than what the employee was receiving from the previous employer. This is to protect the employee's rights and entitlements that they have received in the current employer before the transfer, but it is also some sort of an incentive so that the employee would agree to this transfer of employment because they're guaranteed that they will get the same treatment and they'll get the same benefits and salary or bonus payments even though they transfer to the employer. That is usually one of the points that is heavily discussed whenever we're handling transfer of employment, because that kind of reassurance is usually looked for by the employee. Next slide, please. For the third required document is the statement of acceptance. So this would be a simple statement letter from the employee, only signed by the employee. It has no involvement or signature from the current or the new employer. It would set out just a general statement of the employee's consent and acceptance to the terms of the transfer of employment as stated in the employment transfer agreement. As it is a statement letter, there's actually no standard format or any mandatory content, so it can be adjusted on a case-by-case basis. For example, we have one case where this statement of acceptance is also combined with consent for the purpose of processing personal data. If in that case we did not have a separate document for the consent for personal data protection, so we combined that with the statement of acceptance. That is that's allowed, and you can always make adjustments that are necessary depending on the situation of each transfer of employment. Okay, so before moving to the next point, do you have anything to add? No? So let's move on to the next topic, which is the important points and some FAQs on transfer of employment. Next slide, please. These are just the key points on when discussing transfer of employment. Because as I said, there's no statutory or mandatory obligation or requirements or limitations. So these are just some key points to remember. The first is that transfer of employment is based on mutual agreement of the parties. So the terms can be adjusted on a case-by-case basis. This means that we hardly have any situation where one transfer of employment is the same with another. There usually are adjustments to the terms as long as it is agreed by the parties. And it's not contrary to any prohibition or any regulation on the manpower law that is doable, as long as it is mutually agreed by the parties. Second point is that transfer of employment does not mean that the current employer terminates the employee. The employment itself is still continued, but with a new employer, and so no severance package is required. In our experience, sometimes employees would ask, what does this transfer mean? Does this mean that I'm getting fired from my current employee and then rehired by a new entity? And in those cases, some would ask for severance payment because termination is identical with severance pay. But it is always important to emphasize and explain clearly to the employee that no, the transfer of employment is different. It's not like you are terminated at all. Your employment still continues. The terms will be the same or at least similar, and there would be no severance package. This is usually an important point to agree on by the current employer and the new employer, because usually when it's transferred, the current employer would not want to spend money on severance payment. They would just have the new employer to acknowledge and carry forward all the terms and the service years of the employee to the new employer. So the third point is that the years of service with the current employer must be carried forward to and acknowledged by the new employer, mainly because the employment itself still continues. So there's no termination. Next slide, please. Next point is that transfer of employment can be applied to permanent and fixed-term employees. As just a brief explanation, in Indonesia there are two types of employment agreement for Indonesian employees. The first is a permanent employment agreement, and the second is for a fixed-term employment agreement. There is no limitation on which type of employment can be transferred. So as long as it is agreed and there are clear, there are clear lines or terms contained in the transfer agreement, then both permanent employees or fixed-term employees can be transferred to a new employer. Next point is that it is important to avoid any pressure or duress towards the employee to agree with the transfer of employment. This goes back to the main issue that transfer of employment can be done if it's consented or agreed mutually by all parties. We never encourage any type of pressure or forceful or duress towards the employee to agree to transfer, because it must be done voluntarily or consented by the employee, and this would create a risk of future claims from the employee. And the last point is that remuneration and mandatory benefits at the new employer must be equal to or more than what the employee was receiving from the previous employer. However, there is an exclusion for benefits based on company discretion. This may be adjusted. One of the main issues that we encountered in this type of transfer of employment post-pandemic is regarding work from home policy. This type of policy is discretionary based. Each company has a different rules on work from home, work from office. So if there's a transfer of employment, sometimes the policies are different, and it is the employee would raise issues on raise questions more. So which one should I follow? Now, in this type of company discussionary based benefits, changes or adjustments can be made. So for example, from a strict work from home, it changes into hybrid or vice versa. Another example is terms of insurance. Each company usually have different insurance policies. So the detailed terms of the insurance could be different. We have experienced this as well. And, for major changes, it's recommended to inform the employees. But if it's minor changes, usually it's not going to raise a big issue. So that's for the important points to note. Next slide, please.
So what if the employee rejects the terms of employment? So before I respond to these questions, I would like to clarify about the transfer of employment. So sometimes people may misunderstand about the transfer of employment because, for example, we often find in the company regulation, collective labor agreement or employment agreement that the employer can transfer the employee within company or from one department to another department. So this kind of thing actually is not a transfer per se. So this is assignment, because actually there is no change of employer. So the assignment is still within one company. So in this case, there is a lot of question on this. If, for example, the employer wishes to transfer the employee from sales department, for example, to the marketing department, so can the employee reject it? The response is that, so if the employment agreement clearly states that the employer at their discretion can assign the employee from one department to another department within one company, then the employee cannot reject the assignment. So this is different. Because the thing is, sometimes the company regulation or employment agreement use the same wording, but actually the meaning in practice is totally different. So this kind of thing that we need to explain usually to the client. So for the transfer employee in this context is different from the one that we call it assignment, between assignment of the employee from one department to another department, but still within one company. So the transfer of employment in this context is actually change of employers. So what happens if the employer rejects? Because the main issue is that for the transfer of employment, the employer is required to obtain a consent or agreement from the employee. So because there is a change of employer, then in employment agreement, there will be certain clauses. For example, one important clause that should be mentioned in the employment agreement is with regard to the identity of the employer. For the transfer of employee or transfer of employment, because there is a change of employer, so we will say that there is an amendment to the employment agreement. So amendment to the employment agreement require a clear consent from the employer. The clear consent means that you have to amend the agreement. So we need to get consent in writing from the employee. So sometimes, well, like Susan said, we often ask the employee to sign new employment agreement. But in certain situation, for example, probably the new employer doesn't want to have a new employment agreement, just simply amend the current employment agreement, because probably there is no change or significant change to the terms and conditions. So it's merely only change to the employer. So in this slide, if the employer rejects the transfer of employment, meaning that there will be, well, there are some scenarios here. The employee could be terminated, or the employee remains in the current position. So it depends on how the employer will conduct this kind of situation, will implement what will be the next step if the employee rejects the transfer of employee. Why the employee rejects the transfer of employment? There are several reasons. For example, probably the explanation is not clear. So why there should be a transfer of employment? So why you have to choose this employee to be transferred to the new employer? And what happened with their entitlements? What happened with their future employment in the new employer? Whether it will be more beneficial for the employee to agree to transfer. So this kind of thing need to be explained clearly to the employees. And the second thing is that it is also important to explain the remuneration and benefit, whether they will remain or there is a change of remuneration and benefit. So like Susan previously advised, that there should no change of remuneration or benefit. So basically it should be equal. Equal meaning that ideally there should no equal means that the new employer cannot provide less generous remuneration and benefit. But in some situation that we experience, it could happen that the new employer, for example, will change the medical reimbursement with the medical insurance. So it means that, well, actually maybe the value or the number or the figure will not change, but probably only the method of the what we call the method of the reimbursement of medical, because medical reimbursement probably the process will be more straightforward compared to if the employee enroll in medical insurance. Because there will be certain bureaucracy because you have to submit because you have to submit the copy of the receipt of payment to the third party. So it's a bit complicated. So this kind of thing sometimes it's sensitive. You have to explain to the employee, actually there is no change to the value. So it's only change to the formality. So this is important because the employees want to make sure that there is no change of their remuneration and benefit. And it is also possible that the new employer or the current employer or both agree to give like incentive, just to make sure that the employees will agree with the transfer. So it only to make sure that there will be a smooth transfer of employment in the future. So this kind of thing can be discussed. Of course, the downside is that if you give the incentive payment, you will create a precedent. So if in the future there will be another transfer of employment, it is possible that the current employee will ask for the same treatment. So before you conduct transfer of employment, we need to consider what kind of incentives that will be paid if we want to conduct this in a smooth way, or second, whether there will be a change of remuneration benefit, or if there is one, then what kind of the changes, and then how we explain this to the employees. And the third one is that we need to anticipate what happens if the employee then reject the transfer of employment. Well, in our current experience, there are more employees that reject the transfer employee, because probably sometimes they will think that, oh, after I accepted the transfer of my employment, whether in the next 1 or 2 years there will be a reorganization and so on. So this kind of thing usually will be asked by the employee to the current employer or to the new employer. So they want to have certainty of their future employment in the new employer. Next slide, please. Can the employer ask the employee to resign? The answer is no. The resignation, in theory, must be voluntary. It means that it should be initiated by the employee, not initiated by the employer. Because the wording in law is clear, voluntary resignation. Of course, that in practice, there are some companies ask the employee to resign. Why they commonly apply this resignation scheme? Because the entitlement is different if the employee is terminated. So for the termination employment, there will be, it's common that all the employees will receive severance package. So which from the calculation point of view, it's more generous than if the employees resign. Because the employer will, for the resigning employee, they will not get any severance pay. They only get separation pay and untaken annually but not forfeited, which will be maybe the amount will be less significant if they receive a severance package. So asking or forcing the employee to resign may result in future claims, because here again the key term is voluntarily. So there are a few cases happened in the past where the employer asked the employee to resign. So, but when they ask the employee to resign, in fact the employer also give a certain payment, even though it is not a severance package. So they give more payment than the statutory minimum that the resigning employee should be receiving. And this kind of payment, additional payment, usually will be used as evidence by the resigning employee that actually they are under duress. So they are under duress because the claim usually will be, if I was resigned, I should have got the separation pay and the untaken annual leave, not the additional payment, which we usually call it as an incentive or sweetener and so on. So so resignation scheme is usually not recommended. And the second question is that, can the employee be terminated? Well, if the employee rejects the transfer of employment, the employer cannot terminate the employee strictly for the refusal of transfer. So for the termination, the reason for termination are very limitative. So the reason should be based on the manpower law, the common regulation or collective labor agreement, not because the employees reject the transfer employment. Of course, that if the employees rejected the transfer employment, but there is no work anymore, or their position are eliminated, it is no longer available, the last resort will be termination. But this is not because the employee rejected the transfer employment, because there is a redundancy. So because, for example, the current employer will be closing down. So it means that, well, you have no choice than terminating the employees. So in this case, then the reason for termination is, for example, due to efficiency, closing down of the current employer or the current company. And of course, that there will be several steps that need to be taken for terminating the employees. Next slide. Next slide, please. Here is the procedure for the employment termination. So there are several steps here that you can see from our slide. First, there should be a termination notice. So for the termination notice, this is unlike in other jurisdiction, for example, Singapore or US. When we set termination notice, it doesn't mean that you can simply serve the notice and then the employee will be immediately terminated. So termination notice is only to give, to notify the employee of the intention of the employer to terminate the relevant employee. So there is no standard notice, but at least there are 3 points that need to be inserted in a termination notice. The reason for termination, the calculation of the severance package, and third is that the possibility or the time frame, the termination date. For the termination notice, the time frame is that 14 working days. This should be served 14 working days before the termination date. So at least these 3 key points must be stated in the termination notice. If there is no agreement, because in Indonesia termination of employment should be mutually agreed, or the employer must obtain a final and binding court ruling, which will be lengthy and costly in Indonesia if you choose to take the litigation route. So our recommended action is to have the mutual termination agreement eventually, and then it should be registered with the Industrial Relation Court. So it will be final and binding for both parties. So if there is no agreement from the employee on the termination, the next step is to have the bipartite meeting between the employee and the employer. So there will be discussion here, negotiation for 30 working days. But of course, the time frame is not strict. So it could be longer, it could be even shorter. So if there is no agreement in bipartite stage, then the parties can go to tripartite stage. So either way, either party can file an application to the local manpower office to ask assistance from the local manpower office to have a mediation. And usually there will be a mediator chosen by the head of the local manpower office. So assuming in this stage there is no agreement, then the dispute goes to the Industrial Relation Court. As the employer, because during the termination process, the employer must pay all the benefit, remuneration, and so on as usual. Then the employer needs to file the application for termination dispute as soon as possible to the Industrial Relation Court. So there will be a court proceeding here, like court summons, appear before the panel of judges, and so on. So there will be an evidential hearing, and of course, lastly, the panel of judges will render the ruling. And if any of the party or either party that is not happy with the ruling, then the party can file an appeal to the Supreme Court. So the Supreme Court will be the ultimate court who will render the ruling. So the Supreme Court ruling will be final and binding. So the time frame for the court proceedings could take, in theory it's 50 working days, but in theory it could take like 6 months. 6 months. So the total termination process in Indonesia, if you have a termination dispute in Indonesia, it could take like probably one year. And of course, that in any type of stage, and at any time, the employee can have negotiation and can try to enter into the mutual termination agreement. This will be our recommendation to settle the termination dispute.
Next slide, please. So the last topic would be an alternative method to transfer employee. Next slide. This is not a pure transfer of employment with the same definition that we've been discussing, which is the employment relationship still continues, but with a different employer or an amendment to the employer identity part. This is another alternative to consider if the employer agrees just to terminate the current employment and have a clean slate and rehire the employees by the new employer. This means that not only is the employment relationship with the current employer would cease or be terminated. This also means that the new employment with the new employer would have a different set of terms and rights and obligations. There's no there's no note or there's no obligation or a requirement for the previous terms of employment, remuneration, rights, benefits of the employee to be acknowledged and to be treated as the same as the new employment. And because there is a termination of the current employment, of course, the current employer must settle the severance payment to the employee. As was discussed by Bulia earlier, termination process itself, if there's a dispute, could take a long time. But if the employer and the employee mutually agree with the termination, it could be more effective and shorter process. But it entails with the current employer paying out the severance payment to the employee. Under Indonesian law, severance payment or severance package is actually there are a few elements to it: severance pay, long service pay, and compensation in lieu of rights, which is the encashment of untaken annual leave that is not yet forfeited. And this, the amount of the severance pay would differ depending on the reason of termination. So the regulation, there is a government regulation which gives out the formula for severance payment for each type of or each reason of termination. Now, if this current method or this current procedure is chosen, then the current employer must first settle any severance payment owed to the employee before the employee is rehired or have a new employment relationship with the new employer. Now, as part of the procedure of termination, when there is a mutual termination and the parties sign the mutual termination agreement, then the termination itself must be reported to the Ministry of Manpower. Usually it's the local office, and the MTA or the mutual termination agreement must also be registered at the Industrial Relations Court. Then the option to terminate current employment and to be rehired by a new employer would sometimes be more attractive to employees, considering that first they would receive a severance package, which would usually be a quite substantial sum of money, while still being guaranteed an option or an opportunity to work with an employer, to still have employment with the new employer. And this is why in a lot of cases we do get questions and maybe like claims or demands from the employee who is about to be transferred to instead have a termination and rehire method, which unfortunately we have to say no, because this is a very different form than the transfer of employment that we have been discussing this topic. Next slide, please. So for this type of, terminate and rehire, the documents that is required are very different from the transfer of employment. First, from the current employer side, because there is a termination, so at the very least, there is the termination notice from the employer to the employee. There's a statement of acceptance signed by the employee that he or she does not refute or refuse termination, and then the signed mutual termination agreement. While on the other side, with the new employer, you would need a new employment agreement, which, because this is a purely new employment agreement without any entanglements of transfer of employment, would usually be like a standard employment agreement without including any clauses that we advised earlier when it is a transfer of employment. And maybe there are other onboarding documents that needs to be executed. But this is a discretionary basis, depends on the policy of each company. So with that, the required documents are different. The method is very different. And it seems that it may be deemed a bit more, not a bit, maybe a lot more beneficial to the new employer, less beneficial for the current employer, because the current employer would need to pay severance, make sure to terminate all employment properly, while the new employer would not need to be, required to carry forward any terms or benefits or remuneration that was granted in the current or like the previous employment. So this is, although this is not a transfer of employment per se, this is also one of the methods to consider for companies if they are, planning to transfer employees to another entity. Okay, next slide, please. I think that those are the 4 topics that we've been discussing for today's session. I think we can move on to the Q&A session with Dan from Mondac.
Brilliant. Thank you very much for that, Susan and Leah. An incredibly informative session. We really appreciate your time today, so thank you again. As you say, Susan, we now have some time for questions. We do encourage you to get in touch with Susan and Leah after the webinar if you need to, and we will bring their contact information up. You should be able to see it on your screen. Now, some of these questions we have already touched on, but it's always good to reiterate and clarify where we can. The first question we have is from Caroline. With respect to the statement of acceptance, is that still necessary since the employee's consent to transfer of employment would already be provided when the employee signs the tripartite employment transfer agreement?
Okay, for Caroline's question, actually, we included the statement of acceptance is for completion purposes. We understand that, in general, the acceptance itself is already included in, or like the consent of the employee is already included in the transfer of employment agreement, the employment transfer agreement. So the statement, a separate statement of acceptance can be taken out or maybe adjusted according to the situation in each case. As we described earlier, there is no standard or a strict list of what are the documents required. We would need to refer to on a case-by-case basis. So it's free to be, you can be adjusted depending on the situation.
Brilliant, thank you. The next question we have is from Subitra, who asks, for an employee who refuses to the transfer, does that mean his or her employment will be terminated, and will he or she receive a separation package?
I think with this question, it depends on the situation. I mean, here, if for example, like we explained before, so for example, if the current employer actually is still there, I mean, still open, and position remains, it is possible that actually there will be no termination. So it means that the employee will remain in that position with all the benefit and so on. But it is also possible, for example, if the employer, the current employer is permanently closing down, it means, yes, there will be termination. So for the termination, the separation package will be received by the employee. So there will be a certain calculation for separation package, or we call it severance package here. But the reason for termination is not because they refuse to be transferred, but because of redundancy or efficiency, because actually there is no work or there is no position available for the employees. So we cannot use the reason for refusal as a reason for termination. Thank you.
Brilliant. Thank you, Leah. Our next question is from Shirley. There are a couple of points to this question, but if I start with the first pass and then if you can answer that, and then we'll see if we can move on to the others. Can we transfer Indonesian employees to other entities within APAC? Is this possible?
Yeah. Well, actually, it is, but of course, that probably because it is outside Indonesia, of course, you may want to also observe the prevailing regulation in the other country. Of course, it can, and then it depends on will be subject to the employee consent, whether actually they will agree. But the other entity means that it is not within same group. Yeah, I mean, it is totally a different group, different or change of employer here, because like I said before, it is possible that probably this is maybe only assignment if this is actually the assignment or transfer of the employee from one group, one company to the other company, but actually it's in it one group entity. But of course, that there will be an argument. Actually, the employer may claim or may argue that, well, this is a change of employer, so I don't want to move on to the other entity outside Indonesia. So if you think that certain employees can be asked or can be requested to move from one company to the other company outside Indonesia, you may want to clearly state this in their employment agreement. So there will be, to avoid a misunderstanding of whether this is a transfer of employment, like in this context, or is it actually only the assignment of the employee to different role or other department.
Excellent. Thank you very much, Leah. I'm just looking at the time, and I think that we will have to end our Q&A session there for today. But thank you very much for all of the questions that were sent in. Apologies for any that we weren't able to get to. You can see Leah and Made's contact information in front of you. We will be following up with their contact information too. So please do get in touch, and we'll be sharing your contact information, of course. So I will hand over to Leah and Made to close off today's session. If there are any key takeaways or closing comments that you'd like to make today before we end today's session, we'd be delighted to hear them. Thank you.
So I think for our closing note is that to make sure that you have to make it clear whether assignment or the transfer of employment, because sometimes it's mixed up in employment documents. And second, if there is a transfer of employment, it means that there will be a change of employer. It means that the employer needs to get a clear consent from the employee.
Brilliant, thank you. I think that's a fantastic place to end today's session. So thank you again, Made and Leah, for your time. It's been a pleasure to spend an hour with you today. Thank you also to our audience for being with us. It's been a real pleasure. We hope to see you again. Goodbye.
Goodbye.
Bye.